Good afternoon, good morning, everyone. Thank you for joining this webinar. This is Alex Blumrosen calling in from Paris, France, where we are at Paris Arbitration Week. And you have joined the panel on artificial intelligence and arbitration that is organized by the Silicon Valley Arbitration and Mediation Center. We have an incredible array of panelists today to discuss this subject. But before we get started on the panel itself, before I introduce the panelists, I'd like to ask Sarah Reynolds, the president of SVAMC, Silicon Valley Arbitration and Mediation Center, to welcome everyone and to say a few words about SVAMC, what it does and where it's going. Sarah?
Thank you, Alex. I appreciate that introduction. And I'm sorry I'm not able to be there in Paris with all of you, though I am right across the channel in London, waving from afar. But I understand it's been an exciting week there in Paris, and so happy to hear that in-person events are back on calendars. And Alex, thanks to you for all the effort you put into organizing today's event, and to our panelists for sharing their insights with us. And thanks also to the Paris Arbitration Week organizers for including Silicon Valley in this week's events. We look forward to a continued partnership in bringing together technology and ADR interests. And with that, I don't want to hold up the substance of the program because I know we do have a lot of great material to cover. So I will hand it back to Alex, but thanks to all who took the time to participate this afternoon.
Great, thank you, Sarah. From an organizational point of view, I'd just like to add this about SVAMC's participation in Paris Arbitration Week. This is the 5th year that SVAMC is participating in a Paris Arbitration Week panel. And we, as always, are very thankful to the organizers of Paris Arbitration Week and to all our attendees for being part of this event, which has become a signal event for SVAMC each year. I understand that we have close to 200 registrants on this webinar alone around the world. And so thank you to PAW for that. So why don't we jump right in, because we have an hour and 15 minutes and we have a lot to cover. If my voice sounds a little bit difficult or thick, it's because I'm just getting over a little cold, nothing to worry about. And I know that I have plenty of helpers here on the panel to do the talking. So I want to introduce who we have. But what we will do is I will introduce them one by one in the order in which they're going to make an initial presentation. And each time I introduce one of our panelists, they will take a couple of minutes and give some background and some information about AI and how they see it, how they define it, how they see it impacting the arbitration process. And then after that initial round of discussion points from our speakers, we will open it up for a discussion, a real panel discussion. We have lots of issues that we want to raise. The speakers will be able to ask each other questions, and hopefully there will be time at the end for all of our attendees to ask questions through the chat box that we can get to and get everyone involved. So the first person I'd like to introduce is Charles Morgan. And Charles is a partner with McCarthy Tétrault in Toronto. He is the former president of the International Technology Law Association, ITech Law, for those who know that association. And as the president of ITech Law, when he came in as president, this is 3 years ago, he took on a publishing project, which was very unusual for ITech Law at the time, which was to produce an opus about artificial intelligence called Responsible AI, a global policy framework. And that document, and Charles may be able to tell us a little bit more, is available on the ITech Law website, and it has been the basis for a lot of discussion and thinking in the last couple of years about the role of AI and ethics in the tech world in general, not specifically in arbitration. And so I'd like Charles to give us a little bit of a background, maybe his definition of AI, how it works, what the benefits are in general, and what some of the challenges are. Charles?
Thank you, Alex. So just, by way of update, so we initially published the Responsible AI book in 2019. It's been an updated version was published in 2021. And we're about to publish a green paper, this essentially the same working group, a green paper on the new draft EU AI regulation using the policy framework that's set out in the Responsible AI book as a framework for analysis. So, I mean, AI, I don't want to, I think everybody on the call understands what AI is, but it essentially using data input methods such as natural language processing, voice and image recognition, AI and machine learning, automate the process of assessing huge amounts of data and finding patterns within that data that then can be used, among other things, with predictive results. So assessing data patterns that will then allow the machine learning through a training process to be able to then be applied to other data sets and achieve predictive results. So automation and AI are being used in a huge variety of contexts, even including autonomous vehicles. But here, in the context of arbitration, there are a number of use cases. You can appreciate the AI managing data sets to assess decisions that have already been rendered in order to predict outcomes in future decisions is one of the obvious ones. AI used in a discovery process through natural language processing to go through a huge volume of materials that may be relevant to an arbitration process and establish which materials are most relevant that can simplify the process. And it raises, or even translation. I mean, AI is used to do in arbitration processes that involve documents in a bunch of different languages. It can speed up and reduce the cost of translation. So just at a very broad level, I wanted to flag a few issues that might help frame the discussion that we're going to have, or elements of the discussion that we're going to have. And the first issue I wanted to talk about is the access to justice issue. AI and automation are good at finding patterns in complex data sets and then being able to predict a future outcome based on that understanding. As a result, they work better in areas where there's lots of similar instances and structured data. So it's AI in this context is particularly effective, for instance, in a class action scenario where there might be a whole bunch of different individuals involved in an instance, and you want to assess a huge amount of data. It's better in sort of lower value, less complex cases. The more data, the better. And so a few examples of where AI is being used in mediation and arbitration in an effective manner is the British Columbia Civil Resolutions Tribunal, which is an online small claims tribunal, has using the Smart Settle One tool, has apparently been able to resolve 98% of the small claims through simple mediation, greatly reducing the cost and time and the haggling efforts involved in those kinds of disputes. The Federal Court of Australia uses AI to help split family assets in divorce separation proceedings. Again, low cost, efficient, takes the emotion out of the process. Let's just get to the facts and come up with an objective outcome. And clearly it can speed up research and discovery and reduce cost. But these tools, so from an access to justice perspective, in theory, AI can reduce costs and bring, predict outcomes in a way that could increase the access to justice. The issue is, on the flip side, is that the tools may be available only to some, especially since arbitral awards are often not public. And so there's a dual-edged concern here that only some entities or individuals or law firms may have access to these tools that would give them an advantage into a dispute. And the second related issue I wanted to mention is this issue of informational asymmetry. You can imagine a situation where a big tech company proposes to allow its users to use AI-enhanced dispute resolution tool to resolve disputes between the company and consumers. Well, there's an informational imbalance that's enormous. Those who are the individual consumers wouldn't have any understanding of how the tool works, the parameters that are used to decide decisions, and it raises that issue of trust. Are those who use the system going to trust the outcome? I think that that information asymmetry may fall away or be reduced in the context of large international arbitral disputes where you have sophisticated parties on both sides, access to a third-party independent tool, for instance, or tools of equivalent sophistication on both sides of the ledger. The third sort of broad issue is using AI in any context is the well-known problem referred to as the black box concern. Neural networks and machine learning involve any number of parameters being applied at level after level after level, and it's not always clear, even to those who've developed the system, how the outcome is achieved based on the inputs that are entered into that black box system. So it raises two issues of both transparency and explainability. Transparency being, how does this machine work? What do I know fully? Do I have a clear understanding that when and where AI systems are being used in a decision-making process? And explainability, do I have a real understanding in how those the decision, what were the parameters that led to the outcome, such that I trust in that outcome? And it goes to a matter of basic procedural fairness. And I noticed that the ICC Commission report, leveraging technology for fair, effective, and efficient international arbitration proceedings, said that there's terrific potential benefits of predictive coding, including the cost and time savings that I mentioned, and enhanced accuracy and transparency, provided that the use of predictive coding and the relevant parameters are disclosed to the parties and the tribunal when it's being used. So maybe two final issues that I wanted to flag, and these are well-known issues, and they're problems that engineers are trying to solve, and that anybody who's using an AI system should be trying to solve. And then the first is the fairness and non-discrimination issue. As you can appreciate, poor quality or non-representative data sets that are used to train an AI system can lead to unreliable or discriminatory or unfair outcomes. And there are many examples of this. One often cited example is the Compass case study, where a tool was used by a county in Florida to predict recidivism. So those who were thinking about having people be sent out on probation, what was the risk that they might commit another crime. And it turned out that as might have been anticipated, the data sets led to discriminatory outcomes because they they incorrectly labeled essentially African Americans as being high risk, just based on non-representative data. Obviously, that had a huge and unfair discriminatory outcome. And I think a quote in this space that I just found incredibly revealing is that there's a Toronto-based company called Blue Jay Legal that uses AI to predict outcomes in tax disputes and employment law disputes. So they have huge volumes of data that their AI systems review to on how courts have responded in certain tax disputes or employment law disputes. And at the end of the day, the CEO of that company was indicating that their software, what it does is it really minimizes idiosyncratic bias, i.e. the ad hoc bias that you may have with any, if you were to look at any particular case and any particular judge. But basically all you're left with, said the CEO, is systemic bias, or the general approach of the courts as a whole to a particular issue. So it's important to realize that the quality of the outcome is only going to be it'll be entirely dependent on the quality of the data that is being used. And it'll also be, and this is where transparency and explainability are so critical, it depended on the actual accuracy, reliability of the algorithmic system itself. And I'll just end with this, and to give the example of the state of Michigan in the United States, another well-known example, implemented a data system, and Michigan Integrated Data Automated System, MIDAS, that was used to determine whether or predict whether somebody was engaged in unemployment fraud. So trying to get unemployment insurance when they didn't benefit, they shouldn't benefit from it. And initially, everybody was thrilled with the outcome of the system. They managed to catch something like 45,000 people who were fraudulently defrauding the unemployment insurance system. They were garnishing wages automatically, and they were recovering huge amounts of money that would have been paid out. Well, after looking a little bit more closely, it turned out that it had a 93% error rate. The system was there was simply an error in the algorithm, and it was being used inappropriately. So I think there's a lot of positive upside on the use of AI in the arbitral space and in the context of the legal proceedings in general, but very critical to think through issues of data quality, which lead to fairness and non-discrimination issues, reliability issues, and the fundamental access to justice issue that I mentioned at the outset.
Great. Thank you, Charles. And thank you for providing the segue to our next speaker for this initial presentation, Stephanie Cohen. Stephanie is a Canadian arbitrator of international and domestic disputes. She's based in New York City, admitted in New York and in Ontario. She is well known for her work on technology in arbitration. And in particular, Stephanie is or was the chair of the ICC Commission Working Group on Information Technology in International Arbitration, which Charles just referenced, and which Stephanie conveniently, I believe, has sent a link to in the chat box. And so now I'm going to send it over to Stephanie so that we can get into the meat and potatoes of arbitration and AI, now that we have a little introduction to it. And in particular, what really jumps to my attention is this black box notion, because arbitration, in my practice and my experience, is based on transparency and the ability of the parties and the arbitrators to understand what is going on. And it seems to me that when you have something called a black box with algorithms, however they are generated, making predictions, making decisions, helping or deciding, this could pose a due process issue. And as we know, under the New York Convention, lack of due process is a potential ground to annul an arbitration award or to avoid enforcement of an arbitration award. And we should all be concerned that using AI in the wrong ways or using the wrong AI could potentially impact the very enforceability of the arbitration awards that we're all trying to generate. So Stephanie, could you weigh in on this?
Thanks, Alex. Well, I think just to sort of take a step back, I tend to think of artificial intelligence on a spectrum. Charles was speaking about a number of different applications for artificial intelligence that ranged all the way to the decision making. And I think some of the concerns that you just raised about the black box primarily, not entirely, but primarily can shift towards that end of the spectrum if we were using artificial intelligence to help generate decisions. And in the kind of international arbitration that we are practicing, that people on this call, and I suspect most of our users, that's just not a reality that we are in today. There are services where you can use artificial intelligence to help generate decisions, but that is not really the reality of practice today for the modern sort of international arbitration practitioner. I think the transparency elements really more come into play when we drill down on the nitty-gritty of how people are conducting their cases. So the predictive coding example that Charles gave is one example of a use of artificial intelligence where practitioners are using the technology. They may not realize it. They may think of it as machine generated learning. I think that's basically the same, it's the same thing, that there's a coordination between the sort of human element and the machine. And so the predictive coding is being used to help identify relevant documents when there are document requests. Charles quoted from the ICC commission report, and I think what we were flagging when we talked about the use of predictive coding is that there are no rules about using predictive coding. Do you have to disclose it? Those who practice in the United States and to a lesser extent Europe are going to be fairly familiar with the tool because they're using more used to producing documents. It probably scares people from some of the civil law countries as we start to talk about electronic document exchange and the use of some of these tools, that they may be less familiar with it. And the idea that you don't know that someone is applying an algorithm to carry out their obligations to search for documents may be surprising. So I'd be interested to hear, in the chat or the Q&A, if that's of concern to people at all. And perhaps we can, talk about that a little bit further. I think the one other sort of overarching concern that I would flag, Alex, as we move forward is privacy and confidentiality, cybersecurity, data privacy issues. Right now, you might have noticed that we have a live transcript available that is powered by artificial intelligence. There's a company called Otter AI that generates that transcript. And I would invite you, I'm not going to be offended, open up your web browser, look up Otter AI and go to the bottom of the page and click on privacy and security and scroll through and read what they have to say. It's really important if you're going to use one of these applications that you understand the terms of service, that you understand how the data is being used. So live transcripts and document translation are two very prominent ways in which international arbitration practitioners today are making use of machine-generated learning, making use of artificial intelligence, huge potential for savings on time and cost. But you have to be aware that you are, when you use Google Translate, you're uploading documents. Google can retain the documents to use it to help build their vocabulary. Taking a look at what Otter AI posts is very interesting. As I looked at it maybe about 6 months ago, I wish I had saved a copy because I was thinking to myself, I don't think this is what it used to say. It's much more developed. They're talking about using encryption with their servers, about only disclosing information upon request from law enforcement. But there are all these questions that you may not think about if you think, well, I could save the cost of a court reporter. Why don't we turn on the live transcript? I've had it running in the background right now to see how accurate it is. And it's doing fairly well. Sometimes I've noticed, in particular, when people sort of speak from the floor, they're not by a microphone, it's pretty terrible. But the accuracy so far has seemed to be pretty good. When Charles was speaking, I'm a little less attuned to it when I've been speaking, because then I wouldn't be looking at the camera. But you might want to click on that and just watch that as we're proceeding to see this in action, if you haven't really sort of thought about it before. In smaller value cases, and when you don't have, particularly private materials that you're concerned about, using this kind of service, that could be a good backup if someone cuts out on audio, to be able to see the transcript, have it running in the background, right? There are a lot of very practical uses. So let me just end it there so we can move to someone else and we'll be able to get a discussion going. But I definitely think that transparency plus the privacy, security, data privacy kind of issues are really ones we need to be mindful of. And then it really translates into awareness, people not knowing necessarily that they can use some of these tools to reduce cost, and that the technology is being underutilized to a certain extent. There are services you can pay for that improve the human element. So deepl.com for translations is a more secure paid service, but still relatively accessible, I would say, to people for doing translations. I was just reading yesterday on live transcription about a company called Readback in the United States, which takes the Otter AI type model, but you have a real-time person making corrections at the same time, so that you're saving money on that court reporter, because you don't have all the people involved in generating the transcript and doing the proofing, and can move it to a real-time service, but with the corrections of the human. So that's sort of the other piece that Charles, I think highlighted really well, is that when these services work best when, at the moment, when you have to have the human training, so you have that human involvement in it. So that's something to just sort of keep in mind.
Great. Thank you, Stephanie. I'd like to ask Katherine Rogers, who is with us today. And the segue to Katherine's short presentation, based on what Stephanie was just saying, is that it is very useful to distinguish between the AI that we sometimes read about in science fiction, or what it's going to be like in 20 years with decision-making and delegation by arbitrators to machines. That's one thing, and we're not there yet. But there are all kinds of practical implementations of AI, from the discovery to the translation. And I think Katherine is very involved in one aspect of the practical application of AI that exists today, that has some proof of history, because it's used in the real world. And she can tell us what that is about. Katherine?
Great. Well, thank you. And my apologies for showing up late. Apparently, my calendaring AI is a little bit off. So I was confused about the starting time with the time difference that happened when this was scheduled and when it actually took place. So apologies for that and coming in late. I'm going to actually speak very briefly about, I'm going to call it human-assisted intelligence in the arbitrator appointments process. Now, in the judicial context, predictive analytics, and in particular judicial analytics, are incredibly important, particularly in the United States. It's interesting that we are sort of virtually all in Paris, because actually judicial analytics have been criminalized. They're illegal in France, but they're incredibly popular and useful in the United States. We can't really aspire to those kinds of analytics with picking arbitrators, because there are two things you need to have successful truly artificial intelligence. One, you need a lot of data, and two, you need a relatively narrow band of open questions of content. So with linguistic, artificial intelligence, it's, you can use, it can become very smart using, huge amounts of language, even outside the arbitration context, right? Document production, once again, this document sources and the questions that are being asked to be able to essentially identify or exclude documents. We have a wide, range of data for that outside the arbitration context to train those machines to do it. With arbitrator selection, we really don't have that. And we have instead also a much greater variation in the cases. And then I'm going to actually share my screen to show you what I think is the biggest problem, which is that in fact, we also, one second. The biggest problem that we have is that we have almost all our cases are actually not publicly available. And so when you are limited to not just a small amount of data, but non-representative data, right? Because the cases that become publicly available aren't systematically determined, but rather sort of randomly which ones become public. When you're searching for an arbitrator, you need as much information as you possibly can get about those arbitrators and their past history in decision-making to see how well suited they are for your case. So for those of you who are familiar with arbitrator intelligence, our solution was essentially to create a two-sided market where people who have information can exchange that with people who need information, but without, as we do right now, using the telephone. We consider it curated, anonymized exchange of information about arbitrators in a structured way that permits meaningful exchange. That is one area that we have, I think, very interesting information that's not available anywhere else. But what I want to focus on is something that we do that is actually quite analogous to, trying to get rid of some of the, that's blocking, quite analogous. It was actually built to be analogous to judicial analytics. However, because of the limited data, even with investment arbitration, that's where we have kind of the most systematically collected data and the widest range. You still can't really do the same thing that is done with judicial analytics. But we can do some very interesting analytics, and I have a few samples here. So I'm going to just show you these very quickly. Lawyers are notoriously not very good at reading graphs, so if you get them, great. If not, hopefully at least you get a sense of what is possible. So what I have here on the left is looking at all investment arbitrations. At the bottom, we sort by the size of the case. So to the right is the larger the case. And this kind of confirms what we all think, which is duration. So the blue and black are the duration of the proceedings, and the light blue are the deliberations of the duration of the deliberations of the tribunal. You can see we expect it goes up as the cases get larger, right? And this red line is the rate of recovery, meaning the ratio of how much was requested on the bottom, how much was granted on the top. Kind of an elegant downslope with an elegant upslope, pretty consistent. But this changes a lot by arbitrator. So I've just picked a few random ones, excuse me. Look at Yves Fortier's chair. Now he has we've grouped together some of the amounts in dispute because there are fewer segments in his. But you can see actually the rates of recovery can be quite different. Especially with the larger cases. Another one, again, the same on the left, but this time is Bloch-Stegall. And what's interesting is you can see that Bloch-Stegall, when he's sitting as chair, the rates of recovery can be very different and don't correlate nearly as well, for example, to the amounts in dispute. We also have here, and again, I think also on your screen, it's cut off, but here we have comparing not just, not only rates of recovery, but looking at costs. In some cases, allocation of costs is really important, allocation of attorney's fees, we also have data on that. But there are different ways you can split costs, evenly, unevenly, all costs to claimant, all costs to respondent. What we did here is, once again, the recovery rate. So not surprisingly, when the recovery rate, the rate of recovery is very low, you can see a decent number of a percentage of cases go to respondent. One of the reasons why it's important to look at the time, the duration, is because the more complicated a case we see, we might think it's more, or the longer the duration, the more complicated we might think it is. What's interesting to see is that we can, particularly with regard to, for example, Ernesto as chair, we can see there are significant differences in the duration of the proceedings. When you see one that's unevenly split, you see maybe that was a case that gave them a lot of trouble, or a couple of cases that gave them a lot of trouble, but there ended up being no zero recovery. And again, with Fortier as chair with regard to costs, once again, we see some differences. I don't imagine this is all that interesting to you in the abstract, but when you are looking for an arbitrator, it can be really important to be able to identify how they allocate costs, how they allocate fees. We also have questions on duration. Rates of recovery themselves is very interesting. It doesn't mean that it predicts. These are not predictive analytics. These are historic descriptive analytics, but they can show you trends over time and significant differences among arbitrators. These are just when they're sitting as chair. There can also be data when they're sitting as party appointed arbitrators, when they're appointed by claimants, respondents. The reason I show you this, and I'll stop here, is because I just wanted to give you a flavor of what is possible when you have enough data to start analyzing it and breaking it down by arbitrator, comparing arbitrators. It's not necessarily going to point to exactly the arbitrator you want to appoint or give you a concrete answer, but it certainly helps you identify more variables than you could possibly consider just with telephone research or ad hoc research reading the awards. One of the things that we found is that our clients tend to be quite surprised when we show them comparative rates of recovery of different arbitrators, because in many instances, their intuitions about how they'd rule or what the outcomes would be tend to be different than what the reality is. We also have lots of data on document production, how much was granted, what was the standard, and you can also correlate things like document production, decisions about bifurcation and trifurcation with the length of duration of the proceedings. You can see whether bifurcation or trifurcation makes the cases longer or shorter, whether it has an effect on the duration of the deliberations after the proceedings are concluded. I emphasize these because these are the kinds of, I should mention, of course, probably the most important, though I don't have it here to show you, is we have all the data on outcomes of cases, both jurisdictional rulings. So it's very interesting when you see two different arbitrators' rates on different jurisdictional challenges compared, or on the actual claims themselves, whether they were granted in whole, in part, or denied. And you can see the significant trends in the investment context on claims. Again, this is much more possible in the investment context because there is both systematic data. It's not perfectly comprehensive, the data that's available, but it's systematic so that you can kind of do these meaningful comparisons and have a sense. When there isn't meaningful systematic data, what we have is we have replicated using technology, not artificial intelligence, but it facilitates the exchange of human intelligence, that curated platform that we have. So I do think that arbitrator selection is really one of the most, if not the single most important decisions in the case. It affects outcomes not only on the substance, on the merits, but also a number of these procedural issues. As we get more and more arbitrators in the field, I think we're going to have less and less information per arbitrator, which means that alternative ways to understand and analyze arbitrators' past conduct is going to be more and more important. So again, this is not strictly speaking artificial intelligence, but I would say it's a technologically boosted human intelligence. And I think that's important because in many areas of international arbitration, I might be a bit of an outsider, but I don't think we are. I don't think we should even aspire to artificial intelligence, because what you would come up with, I think, would be at best misleading or imperfect, simply because of the limitations on data and the scale of the scope of the questions and the variabilities in that data. So with that, I'll stop there and turn it back over to Alexander.
Great, thank you very much, Katherine. And I forgot to say that Katherine teaches at Queen Mary and at Bocconi in Milan, where she teaches law and ethics. So very apropos, obviously, with these issues. And thank you also for the segue to, just before I introduce the last panelist, You flashed a graph showing Maxi Scherer's decisions. And I know Maxi, I wanted to just flag two publications because there's been a lot written about artificial intelligence and arbitration over the last couple of years. The first shout out is to Paul Cohen, who is SVAMC member and who wrote an article with Sophie Nappert back in 2017 in GAR called "The March of the Robots," that got a lot of people talking about AI in arbitration, although even that wasn't the first. And more recently, Maxi Scherer did a very nice paper for Queen Mary on artificial intelligence and legal decision making, and that is from 2019. And so, and there are a lot of other publications that you can consult. This is not a greenfield area of academic interest. Far from it. There have been quite a few discussions over the years. And I'd like to introduce now the final panelist, Kathleen Paisley with Ambos Law Firm in Brussels, previously with White and Case and Morrison and Forster, and a specialist in particular of using technology in arbitration and issues of cybersecurity and privacy in particular. Kathleen, maybe you can address some of the more general issues of AI in arbitration, the black box, the due process issues, the transparency conundrums, and how we can make sure that all of this remains fair for our litigants. What do you think?
Well, that's an easy task in 6 minutes. Well, I don't want to take up too much time because I actually think it'd be great to have a discussion with this fantastic group of panelists. But what I did want to say a couple words about is, sort of what limits us in being able to develop real AI for purposes of particularly commercial arbitration, and what I think we should be a bit concerned about in terms of using the available information we have for investor-state arbitration, and why I think the ICC, at least in part why I think the ICC has had almost no uptake on its offer to publish awards in the commercial context, and that is data protection. So Edna and I actually wrote an article a year or two ago about AI and the use of AI to predict results. Not so much this, arbitrator selection would be one possibility, likely damage outcome would be another, essentially potentially using AI as a kind of, super duper early case assessment, and why you can't do that in the same way in arbitration as you can in the courts, which is obviously the lack of information. And why do we lack information? Well, for a number of reasons. One is the confidentiality of the arbitration process sometimes. And the other is the application of certain regulatory restrictions on the use of that information, even if you have it. And our concerns, Edna and my concerns about how this does create the potential for even less level playing field than we already have now. Because as any of you know who've been within a 12-mile radius of myself over the last couple of years, the GDPR has created certain restrictions on the way. They didn't create them, actually. They've existed for a long time, but that's another story I won't bore you with, but has raised our awareness of the restrictions on the use of personal data in arbitrations, from arbitrations. And personal data is pretty much anything about anyone who is either identified or identifiable in an award. So, for example, if an award lists a bunch of names, that is the personal information of each of those persons, and they would need to be protected in the way that data is used. So that means that people who are involved in the arbitration process should be even more concerned about confidentiality than they were before, which goes against what I think we all sort of fundamentally like the concept of, which is more transparency, so we can make predictions based upon awards because we have them. And so, and why do I think this creates a risk of a continuingly less equal playing field is, let's face it, the ones who have this data, maybe not to run true AI, but in order to continue what they've been doing for a long time, which is looking at the data they have and making predictions, are big law firms, but much more importantly, funders. So funders probably have the most information about the results of cases, and where they don't have them, they have the resources to go out and get them. I mean, there's a group in California that's done a really good job of going out and collecting commercial arbitration awards in the United States, where they are often published in the context of enforcement proceedings. So once that information becomes more available, we do have the potential to make predictions. I think Katherine, as usual, is absolutely right. The likelihood we're going to have enough available data to make reasonable predictions about commercial arbitrators as such, I think, is probably unlikely. But I do think that we'll be increasing an ability to potentially start to make general predictions about outcomes based upon available data. But that means that we have to have the data, and in my view, the data is going to be the big bottleneck in this whole process. And we all have to be careful, I think, that data exclusivity, as it were, doesn't create even more concerns about the have and the have-nots in international arbitration. So my own prediction is that because of all those reasons, the real use of AI in commercial arbitration in particular will be challenging. And that does create a risk for people starting to think about the courts as being more predictable because they have data. So it's all swings and roundabouts and very interesting. I do think, again, when I was also looking at the different options and the transcripts we're running today and all that, I mean, arbitrators really do need to think about the data protection concerns raised whenever they use personal data in a case. So, for example, if you are doing a virtual hearing with people all over the world, that's the transfer of personal data during the hearing in a way you wouldn't have it if you were in a certain particular fixed setting. So all of these things create interesting questions, and it's just important to be aware of them and to do your best to manage them. So thank you for having me. It's always an honor to be involved in the Silicon Valley project.
Thank you, Kathleen. As always, raising even more questions that we need to tackle. But the one that jumps out at me from, I think, all of our panelists so far, and I'd like to open it up for a more general discussion, is this this inequality of access to data question. Because it's one thing for an arbitrator to have help in decision making with artificial intelligence, or even maybe in 20 years to have a computer make a decision. If it's fair, if it's reliable. It's quite another to have the asymmetry that Charles referred to, or the dissymmetry, maybe that's what they call it in Canada. I think it's asymmetry in the United States, but it's the same thing. It is exactly the same thing, separated by a common language. And it's difficult to reconcile the fairness and the due process that we like to think of in connection with legal proceedings, whether they're judicial or arbitral, with this severe inequality of access to information. Maybe our panelists can address that particular issue.
Maybe I'll start jumping in here. I mean, I think this is what's really interesting about what Katherine is doing, right? I mean, and she'll obviously be able to speak to that, but the idea that you're trying to equalize the information, level the playing field by having more information available. The question I think that we all confront then is, sources of information and what kind of information we're comfortable providing. I mean, Katherine said to me recently, you can provide names of counsel who you've worked with. I feel kind of uncomfortable even doing that. And that's something that the rankings people ask for as well, or global arbitration. There are a number of different contexts. Some people do it, other people don't. I feel a little bit uneasy about doing that. The ICC has started to publish counsel names now. So, as things sort of start to change, but people can still withhold consent. And a lot of people are withholding consent from the ICC in terms of publishing that data up front. So it's hard to know, I think, where the community actually kind of stands. We talk about transparency all the time. But then particularly in the commercial cases, when people are asked, will you disclose this information? There's an unwillingness to disclose it. So as an arbitrator, if counsel want to disclose things, if they're doing that with their clients, that's fine. I personally, so far, have been much more conservative about that. Then I look at, what Katherine does, and I say, well, if there's going to be a report on me, is she going to have enough information? Is it going to be representative? Frankly, then it makes me a little bit nervous, not because everybody, I don't think I've done a good job and my track record won't speak for myself, but I do ask, what is the data set that she's going to have? I don't feel comfortable contributing to it. Is there going to be enough? I know there are a lot of things people haven't contributed. So what's the value of the information? And that's this constant back and forth kind of battle that we have. And I be interested hearing from Katherine a bit more about this, because I know when she first started to talk about the project, there was much, it felt to me in committee meetings and so on, where she was going on talking that there was much more reluctance and pushback, and that the tides has sort of shifted, but more people are using it, but how many people are using it? What's the reaction to it? And are people providing information about names of counsel and so on the sly, or how do people kind of feel about this? It's hard for us to confront.
Yeah, well, I think you did a perfect job of summarizing what is a collective sense of this unease, right? And of the challenges, right? So what our main goal is to actually create data so that all parties can equally access or have a base of information. The way we describe it is we're not trying to put together a dossier that comprehensively assesses any arbitrator. What we do is we create supplemental information that you can build on top of whatever you have. And we think it actually helps even things out, even if it's just building on top. Your question about, are you comfortable giving names of counsel? I will say one thing that's very interesting to me is that women are generally not. I think we've only had one woman arbitrator suggest names of counsel. We do not ask the names of the parties. We don't ask any identifying information about the case, but even names of counsel has historically been considered, for, to be honest, reasons that are not entirely clear if you look at the confidentiality laws, as something that they shouldn't disclose. On the other hand, there are a lot of arbitrators who very readily disclose it. The way we describe the kind of inquiries we make of counsel is analogous to the kinds of phone calls that counsel, usually at big firms, can call and find out and develop. And what we say is, and one of the things I think is incredibly interesting is it's not just fairness within a case where one side has a lot of information and the other side doesn't. It's fairness in the marketplace, right? And so when we talk about diversity, one of the big problems in breaking through diversity obstacles is, who does there tend to be the most information about? The arbitrators who've been around the most, who tend to be older white men from North America and Western Europe. Newer arbitrators are at a structural disadvantage because it's more difficult to find information about them. So I think every single case where you can supplement the information you have on a newer or diverse arbitrator, and any arbitrator, is meaningful. To address some of the questions you have, one of the things that we've done, and we think technology can really help, in a sense, bridge these gaps. So one of the things we've done, we've created something called the Arbitrator's Perspective Survey, where arbitrators themselves can go and say, you want to know my thoughts on diversity? Every case is different. Of course, I assess them. All the questions are sort of couched that way, but you can give some, basic, identification about your views on arbitrator, chairperson selection, document production, securities for costs. And we're finding both that arbitrators actually enjoy filling these out, that parties are finding them very interesting, because you can also compare arbitrators on issues that you think are important. So our tools are all about adding to what's already out there. We couldn't do, because of these limitations, a structured, comprehensive assessment of arbitrators, let alone predictive analytics. But on going back to the comment that Kathleen made about the ICC, I mean, just to be clear of how limited this is, in the first year, which I think was 2019, where they asked everyone, over 800, 900 cases, to consent, there were 10 where the parties consented, not 10%, 10 like the number. In my understanding, I can't remember, my other colleague looked at this, most of them were sole arbitrators in smaller cases. In other words, those 10 are not going to be particularly helpful. On the other hand, you're right, the ICC has, I think, moved the ball in saying, look, counsel names, arbitrators' names are not, sitting in a case, aren't necessarily confidential. They got pushed back, as I understand, on the counsel names. But I think that's shifted. We've seen huge shifts. The first article I wrote about transparency in international commercial arbitration was, I think, 2013. And there has been a huge shift. Many arbitrators still aren't comfortable giving names of counsel. And we try other ways to get them, for example, to just send out requests more generally. But those are obstacles that I think have to be thought about creatively to be able to make more information systematically available, to help make both the market more functional and more fairness as between parties in selecting arbitrators in individual cases.
Could I just make one quick point? I think Charles might want to jump in as well, but I'm coming back to this question of whether, why parties are not agreeing to allow this data to be disclosed. I mean, I think there's a question as to what's in it for them, right? They have very little to gain from, helping out the international arbitration community with their transparency issue. They have a lot to lose on the data protection side, because every one of those witnesses' names, I mean, they have a risk if those are disclosed in the award and one of those people doesn't like it, they have the basis for a data protection complaint, and it's against a lot of people, right? It's against the ICC, it's against the, so I'm not saying that's going to happen, but if I'm general counsel and you ask me, can you disclose my award? I'm like, I'm not taking that risk. The other thing I also wanted to say is I think it's interesting that you said predictive coding in France is illegal. I mean, a predictive use of this. I'm going to have to go look at that law, because my question there would be, I think the next step that we'll watch the space is the extent to which institutions start to look at their data from a predictive way and start to offer services related to that. And there, I think there is a big data protection potential.
As I understand, the law is not only predictive analytics for judges, it's just judicial analytics, even retrospective, saying these judges, here's how they differ and they're weighing in on different issues.
Yeah,
which is pretty interesting.
Yeah, it's the issue, I think, is about making claims about predicting the outcomes given by named judges or arbitrators. I think it's not about using AI for predictive analytics generally. It's about characterizing likely outcomes for certain judges.
That's what I thought it was, and that would limit a lot what the ICC could do.
Can I jump in here and ask a question? I'm going to take over Alex's role for a moment, but so I'm not an arbitrator. I'm a commercial lawyer. Commercial transactions, typically when we're drafting a complex commercial transaction, the decision will always come up. Do you want to allow the parties to resolve their disputes before courts, or do you want to force arbitration? And in a commercial negotiation, it's rarely about cost, because the cost of arbitration is, generally on par. It's with court proceeding. Typically, the reason given to go with arbitration is that people don't want their dispute to be aired in public. So I'm interested that Kathleen, your comment that there's sort of a specific privacy issue that's raised in these arbitration contexts that limits access to the information. that to me surprises me. Like most court decisions are made public, so that the information about the party, except in family law in certain contexts, as far as I'm aware, most court decisions are made public, so that the distinction about revealing the names of the parties to a dispute, for me, it's not so much a privacy issue. It's about the absolute decision of the parties in advance to decide they don't want to air their dirty laundry in public, so let's not be transparent. And so for me, there's almost a fundamental tension between this desire for transparency and the arbitral context, which is saying we want to keep this confidential. And I wouldn't have characterized it in privacy terms. I would have characterized it as part and parcel of the very nature of arbitration and one of the desired outcomes of that process.
Right,
So
but not all arbitration is confidential.
Okay.
So the point is, I was obviously only talking about cases where there would, and even in a confidential arbitration, the award itself will often be disclosed as part of an enforcement proceeding. So the whole arbitration is confidential, and then you don't pay up quickly enough, and the award becomes exposed in the United States, at least in certain places, if you go to enforce it. And so I was really, you're right. I should have clarified that obviously there's a confidentiality issue. Obviously this will only arise in non-confidential cases, and where, but the ICC has said, even if it's not in the enforcement context, let's allow awards to be published, which, for all good reasons. But I actually wrote a whole article for the Canadian Journal of International Arbitration about the application of the Canadian data protection law to arbitration. So if you really want to be bored one day, you can read that. But there is an issue there.
There's one other sort of element about the quality of the data set, and I think read it kind of quickly, but there's some sort of question about this on the Q&A as well. I mean, we could redact some decisions. There's even concern when you do redact arbitration decisions that you can still figure out, who the players are involved because of certain industries and so on. So the confidentiality piece, Charles, really is a hard nut to crack, and you hit the nail on the head on the tensions that we deal with and the institutions deal with. But I think one of the other things that's different between the arbitration and the litigation context is the way in which the decisions are made. Judges, of course, have a sort of a public role that arbitrators do not. And so there's both greater reference to what has been happened in a body of case law, and duties to follow that precedent. I think arbitrators, there's somewhat of a black box about how decision making takes place, but there are also responsibilities to follow the law. And I think arbitrators tend to be very conscientious about that. But you're also influenced in many instances by what the parties argue. And there are differing conceptions in different jurisdictions about the extent to which an arbitrator should do research, or an arbitrator should raise a question that hasn't been raised by a party. And judges, if something occurs to a judge, they're just gonna, for the most part, not always, but they're much more likely to just ask it and allow the parties to respond. I think there are some arbitrators who will do that, particularly in larger cases where there's highly sophisticated counsel. The sort of tension and the balance kind of shifts in other circumstances, and you can be very wary of raising something that hasn't been raised, and think about, is this something that I have to because it goes to my jurisdiction, that there would be a mandatory law issue, or should I really respect the adversarial process and what has been raised. So there are going to be different views about that depending on jurisdictions that are involved as well. I mean, I might be more comfortable doing it, for example, depending on where the parties come from. So many different factors. as well, one arbitrator versus three, a conversation amongst the tribunal. Do we feel we need to answer this to decide? So all of that is really very complex, and you can't tell from the decision that you get at the end of the day what kind of internal debate there may have been and the basis on which the award is rendered. When it becomes public, if people are relying on it and assuming that that data says, well, this is what an arbitrator would do in circumstance X, there may be a problem with drawing that assumption because you don't really know the extent to which, maybe the arbitrator is held back in the way that I described it. So it really is very complex. And that's why I think, that sort of shift back to things like the use for document production in terms of, the very practical nitty-gritty things that we're doing today, that we're underutilizing that technology, and a lot of the leveling the playing field, access to justice, reducing costs, that conversation, it really is important to shift that to the uses that we can really grow, because if we get more comfortable with those and we get better at it, that's when we're able to leverage and move to these other contexts, because we have we're more comfortable being able to do it. We have better information to be able to do it. So that's where I think, really our conversations, as we're trying to better use technology in the space, that's where I think it's really important to try and shift things. Mindful people don't have the same kind of resources, is really focus on things that they can be using, can be focusing on, and that we can be improving in a very meaningful and practical way. Not that we don't have these conversations, but in terms of focus, I think it's really, really important to try and encourage people to make better use of technology that we have, and to improve that technology in the ways that are really tangible.
So Stephanie, I have a question about the black box with this technology, because it's one thing to talk about black box if you're looking to delegate entire realms of decision making by an arbitrator to a machine. And I understand that that's a problematic, and we're not there yet. But doesn't the black box issue appear even when you identify discrete tasks and use the black box in document discovery, for example? Some of that can be cured by party consent, but isn't it troubling that the algorithms and the predictive ways that AI is going to parse the documents in a discovery review will be opaque to everyone, the arbitrators and the parties? What does that impact enforceability? Probably not if it's cured by party consent, but does it raise other problems?
Enforceability, I think the reality is that in most instances, you're not going to know that someone has made use of the technology. If someone's, using Google Translate, to upload copies of documents and get translations, you're not necessarily going to know that. So I think the enforceability issue is unlikely to be a live one, just because no one's gonna know that you've done. But I also, delegating responsibility to identify responsive documents. If I used predictive coding to do that, and someone says, well, therefore you didn't produce the documents that I should have had, and so I didn't have an opportunity to present my case, or was an unfair process. I mean, I can see how the thought process can align there. As a practical matter, I don't think we're going to end up with enforceability discussions on that front. I think because it's so hard to show that the outcome would have been different, and in many jurisdictions, that's what you would have to be able to show, that there was a material prejudice, an impact on the outcome of the proceeding. As another practical matter, I think that we should be having more conversations about when we're using certain types of technology, and we should be doing that at an early case management stage. And that's just for purposes of, good sense. If we're going to engage in a document production exercise in a huge case, then it makes sense to have a conversation about ways we can make that more efficient. And if people can be on the same page about using search terms and date ranges, basic filters, and then it's just a tiny little step further to say, okay, let's agree that we'll each review an initial data set, identify, responsive documents based on these document requests. And then after that, we'll let the algorithm, play the role, and we'll do document production on that basis. And we're not going to waste all the human hours on doing it, because we have relative confidence in the initial data set, because senior lawyers have done the initial coding. That's how that kind of process could play out in a meaningful and tangible way, and it would deal with some of that black box issue, because you're having a conversation about it. If you don't know someone's doing it, it's a problem. I would want to know when there's another language involved on translations, that someone isn't going to upload my documents to Google Translate. And that's a conversation counsel could ask at the outset. You're now asked to raise issues of confidentiality and data privacy and so on at the outset of a case. It's totally appropriate for counsel to ask those kinds of questions, have an agreement on that front. I think it would be unethical to upload somebody else's documents, frankly, using that kind of service if you don't own them. I think there are some risks there, but there are definitely lots of questions, Alex, and it's not just limited to the decision-making context, but that just all favors conversations.
Yeah, well, although I see that, for example, in the data privacy area, and maybe I'll ask this question to Kathleen, who has written quite a bit about the data privacy aspects. There are conversations, but often there are no resolutions, that the issue of who is responsible for data protection compliance, it becomes a hot potato that we can have a conversation about. We can have some directives from the ICC about, but at the end of the day, no one really knows. And everyone is very worried, frankly, even if there is a little bit of a conversation, because no one knows whether it's the arbitrator's job or the institution's job or the party's job. And when I say job, I mean legal responsibility and liability. Kathleen?
I know.
Please tell us.
It's all of the above.
All of the above.
I mean, it depends if the law. So the question is it's the data processing that is covered by the law, and the data processing is done by an individual. And if that individual is covered by a relevant data protection law, they are bound. And that means in many cases, the arbitrator, the institution, the parties and their counsel will each be governed and bound by legally mandatorily data protection laws that are applicable for their processing of the data in that case. So that means not only do we all have to abide, but the rules may be slightly different in ways that could impact. So I think there is no answer to the question, because it's highly case specific, jurisdiction specific, whatever. I did want to take the fact that you by mistake gave me the mic to say one thing in response to a question that was in the chat about mediation, because one of the things that and I see Michael's on the call, so I have to say something. No, I think it is one of the things that Ed and I wrote about that I think is really important, is the possibility that all of this, if we could get more access to data, if we could get more ability to predict outcomes, whether it's technically through AI or through facilitated human interaction, whatever the exact process, the more data you have to predict outcomes, the more likely parties are to settle. Now, you settle for different reasons, but part of it is because you believe you have a good prediction of how likely you are to be successful or unsuccessful in the dispute. So there is an important potential impact on settlement that we will not be able to take advantage of to the extent that we're restricted in our ability to use AI properly to predict potential outcomes, not with an arbitrator or with, whatever, but just generally speaking, based upon this set of facts, this law, what is the likely outcome of this case? The more data we have, the better we can do that, the more likely we are to settle.
There's a question in the chat box from Kirsten Schvett about the kinds of pressure that the race for information is putting on arbitration institutions to share the data. Do any of you have some input, maybe Stephanie through the ICC Commission experience or others, about how the institutions are trying to juggle the balance between confidentiality on the one hand and the race among themselves to be friendly, attractive, and to share information, because there are all kinds of motivations in each direction?
I mean, without speaking about a specific institution, I will say that I know in dealing with multiple institutions and who all have, you know, various initiatives focusing on making information more public, that one of the challenges is deciding how they deal with some of the companies that have evolved and are providing information. Just Mundi, for example, you know, is producing copies of awards that they're culling from court decisions, and that also are getting fed to them. So, you know, as an institution, do you try and feed things to that kind of service? Do you develop a relationship with the service, or do you try and find, you know, provide content on your own? And is it appropriate for the institution to provide the information even in redacted form? Are people going to be sensitive about that for all of the reasons that we've discussed? Or, you know, as long as the third party is doing it, you know, then they can do that, and it's not the institution who's in the position of producing the information. I mean, there are all these tensions, you know, and how they resolve that is an ongoing discussion, which I think really has to do with, you know, what we were saying about where is the community shifting. I think that they want to be responsive to their users ultimately. And, you know, if there's demand, they're going to do it. There's a tension in providing. There's a similar question in the chat that was asking about, you know, what's the alternative to saying you're worried about the reliability of the data set? What's the alternative to not providing, you know, the information? I don't think there is an alternative to that. It then becomes a question about whether I, you know, as an arbitrator or the institution participate in that. Where is the community versus other people? If the data is being gathered from court records and I'm not providing it, then, you know, there can be a certain comfort level with that process happening, other people getting more information. But until there's sort of an understanding that the people providing the decision-making service, that the people are comfortable with them providing certain information, then I think there's a bit more of, you know, the institutions and many arbitrators sort of, you know, stepping back and saying, I'm not going to be the one to provide the information. The ICC, we've already talked about many times, has been pushing the envelope to a certain extent on some of that, but, you know, how are their users responding?
Great. Well,
If I can add one.
Yeah, is that Kathleen?
I was just going to add one point, which is that
Catherine.
I think that one way to work around the sort of case-based, because we tend to really do our research because that's what we know, case-based. But if you look at aggregated data abstracted from individual cases, there's a lot less, I think, problem with the sensitivities of parties. So for example, I think there could be a lot of interesting publications by the arbitrators. I know there's been efforts before and arbitrators have objected in some instances, but I think there's also ways to address arbitrators' concerns on these issues. But for example, if you were to provide data on the average time by industry of a case by arbitrator, it is some of the kinds of insights that we've been talking about that can be, in a sense, you might call it metadata from older cases, but then broken down by arbitrator, or broken down by industry, or broken down by region. That kind of data, I don't believe, raises nearly the same kinds of confidentiality concerns. That is, I think, incredibly valuable data that I think institutions really haven't thought hard about how to use. And then I think the question becomes, do they charge for it? Because once if they're charging for it, it then also raises questions about, especially as an institution that is supposed to be providing a service that's available to all the parties that are using it, if only one party can kind of afford the information. That I think raises additional questions. But I think there are a number of ways, and I'll just, again, one last shameless plug for arbitrator intelligence. That's basically what we do, is we don't ask, we don't start with an award and redact. We basically kind of build up. Okay, what was the industry? What was kind of the amount in dispute? What year was it? What were the, and we focus on what the arbitrators decided. And that's a way to, again, get around this concern of case by case trying to build a comprehensive database. And the other workaround is to have the arbitrators tell us themselves. That obviously that data also has a particular perspective and can, has some distortions in it. But if you put these together, I think you come up with a meaningful mosaic of the arbitrators, decision-making persona, let's call it. And I think I want to just go back to one thing, which is amazing in our world of information. You have these multi-million-dollar, multi-billion-dollar disputes. And, if you're trying to buy a $25 book on Amazon, you can see what 500 other people thought about it, okay? You're trying to make this decision about who to appoint in a $2 billion case, and you basically have to guess. Maybe you get lucky, you talk to a couple of your friends who have this arbitrator, you find a stray opinion there, a stray award somewhere, but that is in some ways crazy, right? Compared to the analysis that goes into every other decision in the case. It's a really hard, nuanced nut to crack, thing to break through, but I do think that there are ways to do it. And I think there are ways to do it while you both respect privacy and you respect the party's confidentiality, and you respect the arbitrator's concerns about being misrepresented or misunderstood. But it does take, I think, creative thinking. It requires technology, but I don't think it's as impossible where we just throw up all our hands. Parties need this information to make informed decisions on arguably the most important decision in their case.
I think we're getting to the end of our panel. Thank you, Katherine. Are there any final comments from our panelists?
One project for Katherine going forward. I would be fascinated, Katherine, if you get any of those disclosures from arbitrators answering, surveys about how they say they conduct cases and how you think that compares to the data you actually have on how they actually do it.
That's exactly what we try to do is triangulate, here's how the parties in council will perceive what they do, at least in some cases, obviously. Here's how arbitrators see, but arbitrators sit on panels of 3, right? So they might want to be able to say, look, whatever's happened on some of my past cases, here's actually my intellectual approach. We have data on arbitrators who granted document production in these cases, but say in their report, I don't believe document production's ever been useful, and I always discourage the parties from using it. That's an interesting triangulation, I think. So we have contradictions, but the contradictions themselves are interesting, I think.
I just wanted to make one quick point, sort of, and maybe age myself a bit, but that's okay. I do think that we have to acknowledge that some of our discomfort is in trying to create an objective truth about what is inherently a subjective exercise. And when you are choosing an arbitrator, let's face it, you can't choose a judge, but you're choosing an arbitrator. And sometimes when I hear the discussions amongst counsel, myself as counsel, I have to sit back and say, you're just trying to make yourself feel more comfortable, because really, ultimately, this is a subjective decision. But I think we have to be careful in terms of the data we have. And that's why sometimes when people take a very small data set and try to extrapolate out, as Michael rightly says, is there something better? But that in a certain way, allows us to pretend we're not making what is fundamentally a subjective decision about who you want to decide your case. So I think it's very interesting. And I think everything that is being done to try and have more information available is helpful, but I think we have to take it all with a certain degree of caution.
Well, maybe I'll jump in there. I just to go back to one of my earlier comments about AI removing ad hoc idiosyncratic bias and just leaving systemic bias. I'm frankly I find it, again, not as a non-arbitrator, a little bit astonishing that Katherine would say that, perhaps the most important decision going to determine the outcome, predict the outcome of an arbitration decision is who you pick as your arbitrator. It seems to pinpoint that fact that there is absolute bias in the process at the heart of the decision making. So I'm hoping that that's not the conclusion to take away, but it does seem to suggest that AI does have a very important role, or could have a very important role, at reducing the level of ad hoc or individual bias in the decision making process.
So I study ethics, as was announced. I have to say, bias is a really hard word because we have cognitive biases. I tend to like the word perspective. We all have perspectives that are shaped from our experience, from our legal cultures, from our personality, whatever. Those are, quote unquote, biases that are acceptable. And that's why we work hard to choose what we think is the right, arbitrator for our case. And in that sense, I think we can make informed decisions, therefore, that are not entirely subjective in the sense that it's just personal taste. And I don't think it means bias in the sense that there's something unseemly about it. I think that's part of why people forum shop. You can't pick your judge, but boy, do people forum shop, because we know that even righteous judges, who are committed to applying the law, have different perspectives that inform how they do it. I think that's the essential insight behind this, not bias. And I only say that because bias is a loaded word and it has so many connotations. And I don't want you to disparage arbitration or arbitrators, because I think it's a great process. And I think by and large, the arbitrators are genuinely righteous and trying to do the right thing in their cases.
What is interesting is I was both, for my sins, I was both at the IBA Arbitration Day in Istanbul and actually at the physical ICC Commission meeting as part of Paris Arbitration Week at the early part of the week. And now I'm in Miami, which is interesting. But at both of those places, there were significant discussions about cognitive bias and really trying to think about these issues in a way that I don't think we did even 5 years ago. So I think that's, even just to bring it out in the open, whatever your word you use, I think is an important shift.
Wonderful. Well, with that, I think we should bring the panel to a close. I think we're already running a little bit late compared to our stated end time. I'd like to thank all of our panelists. Thank you, Sarah, for representing SVAMC and making the introduction. Thank you to Paris Arbitration Week. And everybody stay healthy. And please watch the SVAMC space, because things happen there. Thank you very much.
Thanks, everybody.
Thank you
Take care.
all.